3 teenage girls burned to death in a car that was already on a recall list. The repair never reached them in time. When a grand jury answered, it did something no American court had ever seen. It charged a corporation with homicide. This is the case of the Ford Pinto. In the late 1960s, Ford was losing the small car war to Volkswagen and the imports. Lee Iacocca pushed a new subcompact onto one of the fastest schedules the company had ever run. The target, as everyone at Ford understood it, was under £2,000 and under $2,000. The Pinto went on sale in September 1970. Its fuel tank sat behind the rear axle, inches from a thin bumper. Ford's own crash tests told the company what that meant. In rear impacts at moderate speed, the tank could crush against the differential bolts and split. The filler neck could tear away and spill fuel. Internal papers priced countermeasures at a few dollars per car. The fixes were deferred while the company fought the coming federal standard. None of it was illegal, all of it was documented. Then came the memo everyone remembers wrong. In 1973, 2 Ford engineers wrote a cost-benefit paper for federal regulators. It weighed an $11 per vehicle fix against 180 projected burn deaths, each valued at $200,000. Legend says Ford calculated that lawsuits were cheaper than fixing the Pinto. The record says otherwise. The paper was about proposed rollover rules for every car on American roads, not the Pinto's rear end. And the price on a human life was the government's own official number. That is the honest scandal. The arithmetic was not a rogue act, it was normal. In 1977, Mother Jones published Pinto Madness, and the crash tests became national news. The magazine claimed hundreds of deaths. The documented count of rear impact fire deaths was 27, and the true toll is argued to this day. The civil courts moved first. Richard Grimshaw was 13 when a stalled Pinto he rode in was rear-ended and burned. The driver died. Grimshaw survived through dozens of surgeries. In February 1978, a jury awarded him $125 million in punitive damages. It was the largest such award in American history. Jurors later said they chose a number Dearborn would hear. The judge cut it to $3.5 million, and the appeals court affirmed, finding Ford had consciously disregarded public safety. That June, Ford recalled about 1.5 million Pintos to fix the fuel system. Then came August 10, 1978. Judy, Lynn, and Donna Ulrich were driving a 1973 Pinto to volleyball practice on Route 33 in Indiana. A van struck them from behind, and the car burned. All 3 girls died. Their Pinto was on the recall list. Reports at the time said the recall letter reached the family days too late. An Elkhart County grand jury indicted Ford Motor Company itself on 3 counts of reckless homicide. The trial opened in Winamac, Indiana in January 1980. A part-time prosecutor with a 5-figure budget faced James Neal, the Watergate prosecutor Ford hired, with a 7-figure one. The judge excluded much of the internal paper trail as too distant from the 1973 model. The defense argued no small car could have survived that closing speed, and Ford was already mid-recall. On March 13, 1980, after roughly 25 hours of deliberation, the jury acquitted Ford on all 3 counts. The Pinto died as a product that same year. The case never did. Grimshaw taught corporations that juries would price conscious disregard in 9 figures. Indiana against Ford put a company in a criminal dock for the first time. Such prosecutions became ordinary in the decades that followed. And the memo of legend still fights the memo on the record. Both stories are true at once. A real defect, real deaths, and a legend that outgrew all of it. This has been Under Oath.